Yep, you may proceed.
Welcome to Licensing Subcommittee hearing today. Can I just start off with a few items before we start the meeting? Just briefly reading through the protocols for the remote hearings. Can I just give you the bullet points? Only speak when invited by the chair. If you wish to speak, please raise your hand and direct all communications via the chair. Will everyone please ensure that their mics are muted when they are not speaking, apart from the chair? If you're having any technical difficulties, can you use the chat function, please, to alert the meeting? Applicants and all parties will be asked to leave the proceedings after the item is concluded. And once the applications have been considered, any remaining parties will be asked to leave the hearing. Please do so promptly. Each party will be notified of the decision within 5 working days. If I can hand over to the chair, can we elect a chair, please?
I'd like to nominate Councillor Snell.
Seconded.
Thank you very much. So let us commence. We have 2 items to consider this afternoon. I've been appointed chair. I first need to start by introducing the other members of the subcommittee. We're not allowed to consider licence applications in the wards we represent. So I am Peter Snell and I represent Dalston. Perhaps the other councillors could introduce themselves.
I'm Councillor Brian Bell, represent Brunswick Ward.
And I'm Councillor Prouvier from London Fields Ward.
Okay, so on the agenda that was sent out, there was a mistake. We managed to send out the gambling policy instead of the licensing policy with this one. We are all experienced members of this committee, so we do know and understand the licensing policy, and obviously it's on that these applications are being considered. I am advised by the committee support staff that the licensing policy was subsequently sent out to the applicants, and so I hope that you've seen it and understood it, because that's what we will base our judgment on. They're both variations that we are considering today. Perhaps I could go round and ask each person to identify themselves. Hang on, let's first of all just say there is on the agenda, the bit that is correct on the agenda is item 4, which sets out the timetable for these meetings, and that's what we will go through in each case. Obviously, it's because of these special conditions, these remote meetings, that we're not able to give you a decision on the day, for which we apologise. But we will give you a decision as fast as we can possibly turn it around. And my suggestion would be that you stick to those time limits. We have plenty of opportunity to ask questions if there's anything we do not understand of any of the parties involved. I'm going to go through and identify the other people involved. So the licensing officer, please introduce herself.
Thank you, Chair. Licensing Service received an application for variation of premises license.
Hang on, you're going ahead of yourself. I'm still doing introductions. Sorry. Just say who you are.
Right. I'm Swangni Shuljamana. I'm the Principal Licensing Officer.
And a bit of a new face to us. We miss and wish Mike Smith, your predecessor, the best of luck in his retirement. It's strange having a meeting without him. So licensing officer, and then other responsible authorities. So the Hackney Council licensing, is that represented by?
That's by myself, Chair, David Tewett, Licensing Service.
Lovely. And then the police are also represented here today. Can you introduce yourselves?
Yes, PC Kerry Ryan.
Thank you, Kerry. And then all the way through, we will be advised by Amanda North. Say hello, Amanda.
Hello, good afternoon, everyone.
Thank you. Now, Amanda is free to intervene at any point in the proceedings. Pick us up if we're going away from what are our legal responsibilities and we start missing any items. But we do rather rely on turning to Amanda and checking we've done it right as the proceedings go on, so as we make sure, you know, we stay legal and above board, etc. Okay, so who else have I got then in the room at the moment? Do you want to introduce yourselves?
I'm Rabia from Government Services.
Lovely. And well, we got Mario. Mario's going to stay in the background. Mario's here to be the legal fixer, sorry, the IT fixer if things go wrong. So it's very good of him to spend his time listening to our deliberations and rescue us if things go wrong. So I guess that leaves just the applicants, does it? Can you introduce yourselves?
Mr. Heiger here, representing the Stags Head Pub in Hoxton.
So yours is the second application, right? And
Yes.
I think the other person was speaking, but you need to, that's right, you need to come off mute. Well done.
Well, my name is Gökhan Algo. I'm the applicant of Gigi's Italian in Hackney Wick E9.
And that's the first thing we're considering today. Thank you very much, Mr. Algo. So away we go. Anybody want to introduce this first application?
Yeah. Thank you, Chair. Licensing Service received an application for variation of premises license under Section 34 of the Licensing Act 2003 for Unit 3 Spectrum to authorize the supply of alcohol for consumption of the premises and to remove conditions as stated in the agenda. Only police and licensing representation remains. I have nothing else to add. Thank you, Chair.
Thank you. Very succinct. And so perhaps the applicant, Mr. Alger, can explain to us why you want this variation, what you're trying to do with it.
Well, basically, we've been in business for 7.5 years since I think the particular David conducted our last review in 2013 October. I'm looking at my date, and the 15th of October 2013. We've been running a very successful family-run business called Pizzeria. It is very famous in the area. People love our food, and they come for food. And every now and again, well, they want to take with the pizza a pint of beer or half pint of beer or a little spirit or whatever you call it, the cocktails away, and then we want to be compliant with the rules and the law. That's the reason we want to sort of like change and then vary the conditions. That was our aim. So our aim would never be to become a bar business or try to sell alcohol off the premises or just to sell alcohol without any food. But our aim was just to apply for a condition which is there and have a comfortable life to be able to give a pint away with our little pizzas and pastas to someone who is asking for a little drink to take away from our premises. That was our idea. So nothing else has than this. So we are mainly a free food business. That's what we want to be, and we're going to stay as we are.
Have you finished?
Yeah, I have finished.
Okay. Can I just ask, I mean, both the police and the licensing authority had items that they wished to discuss with you.
Sure.
Have you had a chance to talk to them since they prepared these documents?
Actually, I've sent them an email, a very extended email to Miss Ryan and also David, but I haven't received any response from them. So, but they got my emails, and then I checked with Sanaria that they have received my emails. But since then, I have not heard from them. I haven't had any respondent or correspondence from them.
Well, I'm disappointed in that, but you know, we'll hear from them today and see if you've addressed their concerns. Thank you very much.
You're welcome.
Any clarification from other committee members?
Mr. Algar, you appear on the face of your application to be applying to reduce your opening hours by 1/4 of an hour.
No, because we're gonna keep our same hours, which was on our license 22:45, and we're not changing the opening hours at all.
If you look on page 13 of our agenda,
well,
on the column L, you appear to have applied to reduce your hours.
Oh,
is that a mistake?
It is a mistake. It is our opening hours is going to be the same as before. We're not changing opening hours. We don't want to stay any longer anyway.
It is our normal expectation that there is a proper time between end of alcohol sales and closing time. So that's just common sense, quite honestly, and we'd have insisted on it. So thanks for that clarification. Any other questions? Councillor Bell, Councillor Pluvier? No? Okay, so responsible authorities now need to say why they are objecting to the application. Who's going to go first? You're going to go first, David?
I can do, Chair. Thank you. Can I just start by saying that Mr. Alger has sent me emails, I think 2 emails, so apologies to Mr. Alger for not getting back to them. I have to acknowledge that I just overlooked responding to him. I'll keep it very brief, Chair, because it is a fairly brief matter. So my representation is in the agenda, I believe at page 21 of the printed version. We have the printed version, and just sets out that the removal of those, the proposed removal of the 2 conditions could have a negative impact just because it changes or has the potential to change the nature of the premises from what operates under strict restaurant conditions to more relaxed restaurant conditions, so a bar in this, essentially. I mean, Mr. Alger's made it clear that he would most likely keep the premises operating as it is. However, a future applicant, a future licensee could change the premises and the nature of its operation, and just when you consider how it's located directly beneath residential premises, and I believe opposite the site there's residential premises there also, it could have has a potential to have a negative impact on the licensing objectives. The other thing I noted was the layout plan, which I've included the plan that licensing have on file there, and there's a slight difference in the plan that we have, and when you look at the site, you can see that there are some tables and chairs outside, and the area the area shown on the plan as a garden area isn't actually in use, but that's something that we could clarify potentially beyond the subcommittee as well. That's something that we could resolve. I'll leave it there for now, Chair.
Well, hang on, you've left me with more questions that I can just get clarification. So the existing licensed area includes the area that's identified the garden, does not include the area at the front. Is that what you're telling us?
So the existing licensed area, if you look at the photograph on in the representation, this is this is what the premises looks at the moment. So if you're looking at the photograph to the left of the site, that area isn't used for as a garden at all. But on the plan we have, it's shown as a garden. And also the area to the front of the premises, directly outside the front, there's some tables and seating there, which isn't shown on the plan, but this is kind of now being superseded, if you like, by fairly new legislation. So yeah, I hope that explains it.
Right, the legislation only allows that outside use, until next year, doesn't it? After which it would revert to the existing.
Can we just, sorry, Chair, can I just clarify from David before we get onto the legislation? So what you're saying, David, is the current licence does not extend to the building line. So that dotted line on the plan, that dotted line is not included in the current licensable area.
That's right. So the plan that's in the agenda is the plan that accompanies
license as it stands, and then obviously we're not challenging the situation with regard to the change in the law and the temporary change, but as it stands, that isn't licensed. That's fine. Thank you. Just checking.
Okay, we can return to that in discussion, I think. Do we need more clarification from David? No. Okay. So can we then hear from the police? You raised a number of questions in your representation. Have they been answered in the correspondence from the applicant?
Thank you, Chair. I'd also like to apologise. I did think that someone had responded to your email to let you know that we'd got it, so my apologies if that wasn't the case. Yes, my representation was based around the location of the premises and the densely populated residential properties around it. The applicants requested the addition of off-sales, which at the moment is obviously permitted under the Business and Planning Act 2020 that's recently come into force. But my representation talks about the premises becoming a bar, and that is one of our concerns with the removal of the ancillary condition. We obviously always have to think about what's going to happen should the licensee move on and go to a larger premises and someone else comes in. Then there would be no condition in place to make sure that that is a food-led venue and that could then become a vertical drinking establishment in a residential area. So we would propose that the ancillary condition remains, but we would have not too many problems with the off sales. That's it from us at the moment. Thank you.
Thank you. Any clarification on the police points? No, no. Okay, so in that case, we can, referring back to my agenda item 4, there's no other person, that's local residents accepting or supporting in this case. So we're on step 6, which is the discussion. So the police have made the point, I'll put the applicant, the police have made the point that whatever your intention, obviously we have to consider your intention, but we have to also consider the potential that you could simply transfer your license to somebody else, and it would be very difficult. If we want this as a food-led establishment and we want to stay it as a food-led establishment, we need any variation we agree to actually ensure that is the case. Now, the key thing that you want changed is the sale of alcohol ancillary to a meal. If you're running a pizza business, why do you want that removed? I don't really understand that.
Shall I? Can I speak?
Please, please.
Well, the reason is that pizza is that because every now and again our customers are very well. Let me just clarify my position. I live just about the restaurant, and then I have been living here for the last 10 years. Wherever we serve are our neighbors, our customers as well. So there is no, I mean, I know this area quite well. There was no objections in terms of our application, which is the perfect from public. And the last 7.5 years that we've been running this business, but we never had a single issue with our any neighbors, any customers. Therefore, you would have got this response from them anyway. So this is the good idea of just clarifying the situation to the police and then David as well. So we are a very clean business. We run as a food-led business. The idea was just literally we will run as a food business, but every now and again some people come and then they want to take 1 pint away from our premises, not to drink in the premises, of course, away from our, along with the pizza they ordered to come and pick up. And then that's why we want to be complying with the law that we are allowed to give a pint away to them and they could take away from our premises. That was literally our aim. And then we're not intending to do sort of like, you know, become a bar business. And I actually been around for a long time, Peter. I run a larger bar and restaurant businesses for the last 21 years, but 7.5 years I've been running this business. We never intended to do this, and then we are at a certain age, we will never do this, and then our intention would never be this. And then, well, we just wanted to a bit of like a leeway that, you know, we can give a pint away to someone along with the food, nothing else. Or if they come and take a pint away, we give it away, or give it away from us, not drinking at the premises, but taken away from premises. I mean, having said that, I have to talk to you. I mean, I would have loved a bit of response from the police and David as well until now, so we could have discussed these conditions. And I waited for long and for a month or so, and then, you know, not to bring this case over here, but agree on the conditions, and I would have made my cases better in understanding. But of course, they have been busy, understandable. My argument was always been, I mean, when we give the drink away from our premises to someone along with the food, a pint, and then just become a compliant. And then, as I said, I live about the restaurant. I will never, ever distribute anyone, or I will never annoy anyone. I will never make any noise. That's why I said to Miss Ryan and also David as well. I think David dealt with my first application 2013. Ever since, we never had a single complaint in our case.
Sorry, Mr. Alger, can I bring you back to the question? I think Councillor Pluvier may have had a hand up, but can I bring you back to the question I was asking you? Is the police are not objecting to off sales?
Mm-hmm.
You're not telling me anything that explains to me why you want to drop this being a food-led operation. So surely what you're just after is off sales, and you do not need us to remove the condition saying alcohol has to be ancillary to a meal. Sorry, can I bring in Councillor Pluvier?
Yes, there are two conditions here. One of which says, and they're unnecessary to have both, and it's good that you've drawn our attention to this. Intoxicating liquor shall not be sold, supplied, or consumed otherwise. That's condition 12. And condition 20 says intoxicating liquor shall not be sold, supplied, or consumed on the premises otherwise. And if you read that as sold, supplied, or consumed on the if you read all of those as on the premises, then that is the condition that should stand, because we don't want a situation where alcohol is being sold on the premises for consumption on the premises. The reality of the situation is that the law has changed and the applicant has permission for off sales under his current hours. So the question is whether we need to change the license, and he needs to produce a case for us why we should do that, given that the law has changed. He has permission for off sales under the new temporary law for a year at least. You know, I absolutely am happy to withdraw condition 12 because it's not clear. I would like to make condition perhaps 20 a bit clearer, that it refers to meals sold on the premises, and ask the police about that, and whether we're arguing about the need for meals to be sold to as well when with off sales. And I need to talk to the lawyer about how that applies under the new regulations. So sorry to not be very clear, but I'm trying to. So we need to sort out the two conditions because they're superfluous. One of those conditions seems to me to refer specifically to on the premises, and we might want that still to stand. And I'd be interested in hearing whether the applicant is happy to keep a condition that alcohol sales for consumption on the premises continue to be with food. Okay, that is a way of keeping the place as a restaurant. So that's the first question. And then the second question is whether we need to accept this application in any other way, given that he has permission for off sales. And I wanted to check with the lawyer whether whether the conditions under the new law mean that you can sell alcohol without food anyway.
Okay, well, first I think we were asked in the applicant if you're happy that we keep 20 in, and then I think Councillor Pluvier was asking the police to clarify whether they think the wording needs tightening up. So first of all, to the applicant, would you be happy if we kept one of those conditions in?
Well, I'm happy to sort of like keep the condition on when we serve the food and we can give the alcohol, but we would like to have a bit of leeway to be able to serve a drink off the premises. So one of the conditions we can stay, and I wasn't aware of the off-sale alcohol law. Otherwise, I wouldn't have applied for this variation anyway for a year. And then, which is a good thing. And then the government allowed all the premises to give alcohol away off the premises, not to drink within the premises. I mean, we're happy to stay as we are, and then serve the alcohol with the food. That's absolutely fine.
Okay, and Kerry, what's your take on that ancillary condition? I mean, it looks a standard condition to me, but Councillor Bouvier wanted your thoughts on it.
As I read it, I think that condition 12 at the moment, because it applies to all alcohol sales, would prevent off sales at the moment. If that was removed, then he could. But what I'm concerned of is, I think the tables and chairs at the front, if that is not within the licensable space, then that is an off sale, which means we could have a small bar out the front.
Well, hang on, I was planning to come back on that whole issue about the licensed area. I was just going to try and bottom out this one first, if I could. So, Councillor Bouvier also asked, said, could Amanda talk us through the current the status and the changes being brought in on a temporary nature by the government, and how that impacts on, I think, number one, could the place operate as a bar anyway, and number two, the implications for off sales and how long that would remain relevant. Comment on that, please, Amanda?
Yeah, so under the new Business and Planning Act 2020, which came into effect on the 22nd of July, alcohol sales, off sales are permitted up until 2300 hours each day, and the premises license holders don't need to apply for that. That is automatic, and they can they can have that up until that. Those off sales are permitted up until the 31st of September 2021. They can sell alcohol without food as part of the provisions, and my understanding is that some of the conditions can be suspended during that period. But obviously, once the committee make a decision that the alcohol should be sold with food under the application, the application hours will take precedence, but they can still sell alcohol until 2300 hours each day.
Yes, David Chewett, I see you were wanting to come in. Please give us your input.
I think under the Business and Planning Act, the 11 PM is the cut-off time, but not in this case, because the hours at the moment are until 22:45. So that will be the cut-off time in this particular case. The Act overrides conditions in relation to deliveries, open containers, and on sales, but not ancillary sales, not at sales of alcohol ancillary to table meals or anything like that. So if a premises has a restaurant style operation, those off sales would still have to be supplied. Those off sales of alcohol would still have to be supplied with table meals.
Okay. Can I check with other members of the committee? Have we bottomed out those issues, and can we start moving on to the issue about the licensed area? Are people happy to move on, or Councillor Bouvier? No, come on, Councillor.
The issue about the conditions has been resolved yet as to what they prefer to do.
Okay, we need to hear from the applicant, because we need to know if he wants us to remove a condition. I mean, currently, we only have off sales with food, so he can sell. If we give him permission to sell, and under the new law, whatever happens with this license, he can only sell drinks with food. And so I need to know from the applicant and the police whether that's something they want to stick to or not. It's not completely clear I think the applicant has said he does only want to sell alcohol with food, but we need to be clear.
Okay, so Mr. Algo, do you want to clarify that for us, please?
Well, the addition to what Emma said, that of course, I mean, if it's condition 12 is allowing me to sell alcohol without any food, which of course I would have loved to keep it, but David or anyone else who never been to our place for 7.5 years, I know that we never been a bar business. We will never be a bar business, which is fine. But if the condition 12 stays as it is, I love to keep it, of course, as a leeway of, you know, if I give a drink to someone that is there and then without serving alcohol, that is good. Yeah, nothing else I can say that, if I'm not mistaken, the situation.
Okay, so you prefer to keep both. Councillor Bell.
Mr. Algar, if we do agree this, it seems likely to me we'd want to delete 12 as the less complete condition and the less accurate condition.
Well, I need to read it to 12 again myself. Would that be possible? Because I haven't put them in, but I can just pull them up from my file. Is that all right?
Of course.
By all means, we're going to go to the police. As long as you can do that while we're hearing from the police, that would be fine. So,
if I could just finish.
Councillor Bell, sorry.
Condition 20 seems to be the more complete one, and it's also the one that refers to on the premises, while 12 is vague about that point. I think it's the better of the two. If you could indicate you would accept that one, I think we might well be very advanced in our business today.
I need to just, as I said, I need to open up and then read these things because unfortunately I haven't printed them in front of me. It was just a file that I can open up and then have a look at it. Would that be possible?
I'm not sure. I imagine you can just do it. I mean, by all means, just get on and look at that and listen to what we're saying at the same time. I don't think we need to stop the meeting.
Oh yes, you carry on, those. Yeah, it's fine.
Okay, so Kerry, it looks like we're heading towards deleting 12, keeping 20, and we've still got to sort out the licensed area issues. Is that consistent with your concerns about this application?
Yes, I just need to confirm what the licensable area is.
Yeah, okay. So who's going to take us through that one? At the moment, the licensable area is inside the premises and out in the area at the side. I'm afraid David Turrett's picture is not really that clear, but it looks as if the side isn't in use and there are tables out the front. It's not as if it's been enclosed or anything. So what we have is licensed area not being used. Perhaps, Mr. Algo, you can talk us through that. What are you wanting to get licensed? Where are you serving your meals and your alcohol?
Well, we have been using the front of the restaurant for a while. The reason we submitted, I mean, our agent submitted the when we applied for a alcohol license in 2013, open up a door and then move into the garden where we could do our alcohol or premises license within the garden area. Well, since our agent submitted and then did what we just need to tell you in 2013. Well, we find out that in the garden area, there's a little power substation, which is an electrical substation. And then our building is run by Peabody Trust, which is a housing association. And then they warned us, saying, look, guys, you actually not going to be able to use the garden area. Therefore, you need to do your licensing or you can put your tables in front of the premises, which actually still belongs to the premises within our lease. As maybe David hasn't seen very closely to the premises, but where there are tables are at the moment belongs to the premises, to the building. In addition to it, since January, we were aware of the table licensing situation would change for a private forecourt areas. What I have done is to apply for a table license from a table and chair service of the council. I have been speaking to Judith and actually paid for my licensing fee, £700 odd, and she came and measured all the area. And then we liaised a lot. Judith is a fantastic lady who helped me out, saying maybe Amanda would clear out that the government has again introduced a law that we don't need to get a table license for private forecourt for this year only. That's why, and then we agreed with Judith that we will not get a private forecourt area, the license, until the next year, which I will do so, sit down and do that. And then, well, as far as we're concerned, we are, because of the COVID-19 situation, and then we are complying with the rules, and then we need to put these people outside, away from our premises, and then we've been doing so for a long time. And then even Judith didn't say anything, and then, you know, she was happy to grant a table license for that whole area, which she measured, and then we paid for, but of course it got refunded. So
Okay,
this forecourt area is very, very crucial for our business, and then it's been so for a long time.
Okay, thank you, Mr. Algo. It makes your job easier and it makes our job easier if when you come for a variation, you make sure that the variation's bang on and covers everything.
Yeah.
And as I understand things at the moment, you can't use some of your existing licensed area, and you've understandably started using another area that's not covered by your current alcohol license. Now that will outlive any temporary changes. So Amanda, can you advise us, are we allowed to consider as part of this application the idea that we will change the licensed area, because it hasn't been part of the original application, but it was still a census. Councillor Plouvier is telling me we can't consider that, so it would have to, is that right? It would have to go as another application, but it could well be decided under delegated officers' powers. Have I got that right?
Yeah, I think though, although we can't consider that area, it is the responsibility of the applicant to submit or to keep the licensing authority informed of the layout of the area, and to make sure that they submit the necessary updated plans so the records are kept up to date, and it's very clear where their licensable activity is permitted. Sorry.
Thank you very much. Councillor Plouvier.
Just to say that if we give off sales and keep the conditions as they are, then that will legitimise that area as part of their food and drink. And it says the police concern is that we legitimise that area through allowing off sales, but take away those food conditions. So that's my understanding at the moment, is that we can legitimise it by permitting off sales on the licence, but they might not want us to do that, and they certainly wouldn't want us to do that if we withdrew the food conditions. Is that right, Terry?
Yes, please, PC Ryan.
Is there a possibility that we could keep condition 20, add to that condition that it would also apply to food that, or the area at the front, the seating area at the front, so the ancillary would cover the on sales and the seating area at the front?
Thank you. We've got there in the end, I think, haven't we? We okay with that, Amanda? Lovely. And would that be acceptable to the applicant?
That's fine, no problems. That's what we've been doing, Peace, actually. And then, you know, we are complying with all the rules. We're not saying anything opposite to what Peace Ryan's saying. We are so happy to do that because I live above the premises, and then okay. I don't want to do anything that is going to be detrimental to my own property as well. So we are happy what she's suggesting. Serve the alcohol along with the food, even forecourt of the area. That's what we've been doing anyway. And then we have to do it to protect the 7 people's livelihood that we employ.
Okay, can I just say, whatever our decision on this, we're in all probability going to add an informative reminding you of your obligation to notify the licensing authority
Sure.
of any changes in the usage. But let me see, I see Councillor Bell has got his hand up. Councillor Bell.
Yeah, I thought we were clear that we cannot alter the licensed area by this application because he did not apply for that. And therefore we're fixed, Kerry. We cannot in any way extend licensing area to the outside by any action we take, since that was never applied for. And therefore people didn't have a chance to comment upon it.
If I may, my suggestion was that the on sales would remain ancillary, and that a part of the off sales, which would be the area located directly outside the front, would also be included in the ancillary condition, not extending the licensable area, if I'm making sense.
Yeah.
Can we do that, Councillor Cloutier?
Well, it's not that, it's just that you're also saying then that you're happy with off sales, as it were, onto the street to passers-by of alcohol without pizza. And because that's what we're ultimately deciding, is whether there's an off sales of alcohol without, because even under the new law, that food condition still applies unless we say not. You see what I mean? So
Yeah.
So it's if we're granting off sales, we have to decide whether or not the with food sticks to all the off sales, not just the front area, but all. So delivery and people walking past. So they could deliver alcohol to people's homes without pizza. They could sell beer out the front without pizza to people walking past.
Yeah, point taken. I was just trying to make a suggestion, but yes, we would still prefer it all to be ancillary.
Okay. And what about the applicants? Do you want?
Yes, I mean, again, that seems the direction we're heading in, that all off sales and on sales would be ancillary to a meal. Do you have would that be acceptable to the applicant?
Yeah, well, it is the condition that is going to make Peter Ryan and then David, Emma, the rest of the councillors, and then all the guys. And we will happy to do that because, as I said to my email to Peter Ryan as well, we are here to cooperate, not go against anyone. That I don't want to upset anyone. I'm here to cooperate, and I like to carry on with my own business, which pays our taxes and then employs 7 people. Keep going because COVID-19 situation has been so detrimental. Trust us, guys, really. And then we've been crying out. And then we've been crying out for help. And then any help that you can just bring to protect the 7 people that we employ and then their families, it will be so, I mean, you're talking about very specific food business and, you know, the catering business. This is very important. And then we need lots of help, David, and then lots of help for everyone, please.
Okay, I mean, it states in the committee report, it is not our role to place any requirements on businesses. That said, licensing is here as a committee to ensure that the licensing policy is followed. There are extensive business support arrangements, and basically, I mean, email, I don't know, our licensing department, and they can send you the various links to register for the support. But I know a lot of hospitality.
Yeah, that's absolutely fine. Yeah.
So as long as you know those links, but that's another part of the council. That's not really one of our questions. I think we have probably covered all the bases here that we need to make a decision. What do other committee members think? Emma and Brian, are we there? Should we go into closing remarks? So I'll do it perhaps in reverse order this time. I think that would put PC Ryan on first, wouldn't it, as the police? Do you want your closing remarks? Have you heard anything that changes your recommendation? Do you want to make clear exactly what you'd like to see?
No, nothing. I haven't really got much to add, really. We're happy to include the off sales as long as it's ancillary, so it will be a permanent change to the licence.
Thank you. And any comments from you, David?
Just to concur with what PC Ryan has said, so happy with that as long as it's any alcohol sales are ancillary. And I think the issue with the layout we could sort out through separate applications.
Okay, we can do an informed. We don't have any outside people objecting or supporting it. Back to Mr. Alger, we seem to be reaching a bit of consensus here. Do you want to make some closing remarks?
No, it's absolutely fine. I'm happy that, David, I will work with you for the forecourt. And then actually just let you know that we've been using the forecourt for a long time because we've been told that we couldn't use the garden area for a long time ago. But ever since, just make sure that, just give you a bit of peace of mind. 7.5 years. No, you never had a problem. I never had a problem. I don't want to have a problem. But let's include the area. Actually, I apply for a table license as well. I'm here to comply with all the rules that you asked me to, and then that forecourt area is detrimental for our business because it's so good, and then people come for just sit down and then have a meal and go home. Let's do and then carry on with what we're doing before, and then we will be all happy. That's what I would say.
I think the point to take away is that even if licensing doesn't respond to your letters, it's always a good idea to drop them a line if anything changes.
Oh,
so,
yes, because that's what I've done. That's what I've done, Peter.
Okay, and the final person, licensing officer, anything needs to be added?
No, nothing else, Chair. Thank you.
And Amanda, do you feel that we've covered all the legal grounds we need to consider in this case? Lovely.
Yeah.
Okay, committee, final clarification for anybody? No? We now have, I think, everything we will, as I say, have our discussions in private, but I've made notes, I'm sure my colleagues have, and at the end of this meeting we will make a decision and we will notify the applicant as soon as possible. Thank you very much for coming today, albeit remote. Thank you. Good luck with your business.
Thanks so much, guys. Thank you. Cheers.
Okay, so do we want to? I've got this right, haven't I? We now go straight on to the second application, the second variation application. If you want to introduce that, please.
Shall I start, sir? Sure.
Yes,
Sorry.
please. Yes.
Thank you, Chair. Licensing Service received an application for variation of premises license under Section 34 of the Licensing Act 2003 for 55 Osman Road to extend the hours for the Rare Garden on Fridays and Saturdays, as stated in the agenda. Only police and licensing representation remains. I have nothing else to add. Thank you, Chair.
Thank you very much. So, sat through the previous hearing. I mean, this is similar territory, and the procedure will be pretty much the same. So, first of all, can you set out exactly? Did you? I'm just checking. You did introduce yourself. I just want to help our committee clerk and make sure she knows who's speaking. But you want to just set out the case for the changes that you want.
Yes.
My name is Susanna Hatwani. I'm the DPS, and this is Mr. Haika, who is going to speak on my behalf. I applied, but he's the owner of the business.
Thank you. So, away you go.
I'll go first, I guess. Sir, the pandemic situation has devastated the economy of this country and has hit hard, in particular, the hospitality business. Like most central London hospitality businesses, our business has seen a significant drop over the summer in comparison to last year. In fact, we are down 60% on sales since the reopening. In August, we started to see a slight increase in the sales and some bookings started to come along. However, they were all cancelled as soon as the 6 people rule was introduced by the government. Sir, the COVID-19 pandemic has forced us to adapt to new ways of running our business. We cannot have live music anymore as we used to have it. We cannot take bookings for the function room as we used to take them. And we cannot have music events from the music school across the street as we used to have it. All we can do at the moment is maximize the opening hours in the garden on Friday and Saturday. By extending the garden opening hours just by 1 hour over the weekend, we are hoping that our customers will stay longer. And this will hopefully help a little bit our struggle to keep the pub afloat. As announced only yesterday by the British Pub Association, the hospitality will see a spike on redundancies once the furlough scheme is over. We are trying to do everything we can to save our business at the Stark's Head from closing down during the pandemic situation. I think it's worth mentioning that before we took over the Stark's Head business, the pub was somehow a noisy pub, hence why the conditions in the garden were applied. However, since we took over the pub in 2013, we have done an exceptional job keeping the environment safe and quiet. First thing we did straight away when we took over the pub, we introduced strict measures such as noise measuring devices, we soundproofed the live room, we moved the smoke and air from the front to the back of the pub, and now we have one security monitoring the smokers at all times. All those measures have contributed to the noise complaints being reduced from monthly complaints to almost 0 complaints yearly.
Thank you very much. It's very clear. Questions from Councillor Bell and Councillor Bouvier. Are we clear what's the case for the application?
Just to clarify, they seem to have made the same mistake as the previous applicant, and the application you've made reduces your opening hours.
This is the gardening opening hours. At the moment, we have a condition that we have to close the garden at 11 o'clock. We're asking for an extension of that to midnight.
But if you look at page 40 on your application, first of all, that applies to all the hours, all the premises, and you appear again to probably by mistake be applying to reduce them, your opening hours.
On our license, on the conditions here, it says the beer garden at the rear of the premises shall close at 23 hours.
Can you see page 40, your application, the one you filled out?
I wouldn't.
Yeah. I think
it's loading.
Stay with us 1 second, please.
And your existing license, the hours on the existing license are at pages 48 and 49. That's the comparison Councillor Bell is referring to.
Okay. So if we made a mistake, then just to clarify that, all we're asking for is that we are allowed to keep the garden open for an extra hour on Friday and Saturday until the pandemic is over. And this is simply because we're hoping to get back some of the sales.
Okay, you're drifting away from the point. You've made a mistake on the application. That's what happened. That's fine.
The application has only 20 pages.
Yeah, we only have 20 pages on the application, sir. Not sure.
I'm referring to the pages on. Okay. No, this is your existing license, which is attached in the papers for today's committee as an appendix at the very end of the report. And within our report, it's pages 48 and 49. And that is your existing license. So when we get a variation, what we're doing is comparing the existing license, the applied application with the existing license. And what you're telling us now, and we need to get this clear, is that no, you do not want to reduce the hours from those that are already agreed. All you are trying to do is to amend the hours the garden can operate. That's okay. You can do that as long as we're clear.
That is correct, yes. I do apologize for the confusion.
Yeah, thank you very much. Okay, and you happy with that point? Thanks, Councillor Bell, for raising that and noticing it. I don't see anybody else coming in at the moment. So, shall we then go on to the next person, who we will invite? Should we? I don't know. Do we normally have police? It's so long since I've had one of these meetings. Do we normally have police first, or licensing? But let's mix and match a bit. Why don't you come in first, PC Ryan? So, your objections, please?
Yes, our objections are it's not really going to deviate from what I have already submitted. We did do a visit in mid-July where we found a DJ and the music to be very loud, but it was turned down while we were there. I just think it's very late because there's lots of residential premises all around it, some high, so they actually look over the garden. One of the other questions was that the applicant has asked until the restrictions are lifted, but we don't know when that is. So we'd need some kind of date or some kind of I can't think of my words, agreement of when that would be lifted. But as it stands at the moment, police would not support an opening in the garden until midnight.
Okay, can I just, you raised a couple of questions in the comments here. As question marks, has the applicant been in touch with you to discuss those issues at all?
Yes, I have had an email.
Thank you. Questions from other members of the committee? Clarification? No? Okay, well, should we then go over to David Tuitt and perhaps your support, your representation? Can I just throw in a couple of things, David? You may not be able to help us, but number one, have you looked into the noise complaint record on these premises? Are you able to give any figures on that? I know we used to have problems with the database. And number two, what is the status of our policy regarding outside garden space? Do we have written policy about how late it stays open, or do we have custom and practice? So perhaps you could expand on your objection, but then also if you can address those two issues, that would be great.
Okay, thank you, Chair. Well, the initial representation is fairly brief. I mean, the applicant has sought to extend the hours for use of the garden by an hour to midnight, Fridays and Saturdays, which just given the close proximity to the premises of residential properties, that could have a negative impact, in my opinion, on the promotion of the public nuisance objective. So that essentially was the grounds for the representation. In answer to your two questions, Chair, complaints from noise complaints, I haven't looked into any complaints received by our colleagues over in environmental protection, for example, but I'm not aware of any complaints about noise being made to the licensing service in relation to this premises for some time. The applicant has mentioned that they took over, I think, 2013. I remember the premises was problematic before the current occupants took over, so that is correct for them to say that we've not had issues such as we did previously. And your second question in relation to policy on outdoor activities, the council's licensing policy has a specific policy on external activities, external outdoor events and external activities, and that has a 10 p.m. cut-off time, unless the applicant has set out mitigation measures, etc., that sort of thing. So this is beyond the hours they have at the moment are beyond that, of course, but they were beyond that before the policy came into effect in 2018.
That came in 2018. Very helpful. Councillor Pluvier.
Councillor Bell has left the meeting.
I think Councillor Bell sometimes has problems with his broadband access. Can we? Councillor Bell, you are back.
Okay.
Do we need to? Are we okay to go ahead, Amanda? Can Councillor Bell continue to contribute to this decision?
Yes, I mean, Councillor Bell, can you explain what happened just now? Was it a technical fault?
Yes, it was that.
Yes.
It dropped out against my controller.
And do we need to repeat just maybe the last sentence, Councillor Snell? Can you just repeat what you just said just now? Or
essentially, just David, go over those 2 points again, because I think that's all that Councillor Bell did.
The applicant took over, yeah, and then 10 p.m. cut off.
the two questions. So Councillor Bay, you didn't hear my response to Councillor Snell's two questions. So the first question was in relation to noise complaints. I responded that licensing haven't received any complaints recently in relation to this premises. The applicant made reference to the fact that they've taken over in 2013, and prior to them taking over, I do recall the premises being quite problematic. And I think a review application was sought by possibly a pollution team at the time. However, I have not looked into any noise complaints from our colleagues over in environmental protection.
I'm pretty sure I sat on the review application for this premises some years ago.
Okay.
It was some years back.
Yeah. And the second question in relation to policy on external areas, the statement of licensing policy does have a specific policy in relation to that external events and activities policy, which has a cut-off time of 10 p.m. generally, unless the applicant can or licensee can demonstrate that they've got mitigation measures in place, that sort of thing.
Okay, thank you.
Okay, so any clarification sought from David Tuitt? Comprehensive answer, I think. Thank you very much. So where we got to? Local authorities. There's no other people objecting to today's application. So really, we're going to kick off the discussion. I suppose well, we've heard quite clearly from the police. If we were minded to grant this change, and it as David has set out, it would be a big change, given, and we recognise your reputation, but given that you've already got permission to use the garden longer than is our current policy, this is quite a big ask you're putting before us. And as PC Ryan has made clear, if we were going to do it, it would have to be in some way time limited. Do you want to just come back to us on those 2 points?
Yeah, sure. Yeah, I was. Thank you, sir. Yeah, just quickly on the just referring to the police visit on last month. The event we had is a regular event, and it's by all means not a trouble event. It was the very early days of people obviously going to the pub after lockdown. So one of the DJs did get a bit excited, and he turned the music a bit louder than he's supposed to. We have banned him for ever playing here again. And even on the day, we moved our security in the garden next to him, to the point where the security was literally forcing him to turn the music down. So we do apologize about that. It was an incident which we tried to control. And like I said, the DJ has been banned from playing here ever again. But the event in itself, it's a regular event at the pub, and the average age is between 40 and 60. And the music that normally gets played is 70s and 80s music, background music. By 10 o'clock, the event was over. Everybody left in an orderly manner. And I think everything that we did that day, I would say, would fall within the compliance of trying to reduce the noise complaint, even though, like I said, one of the DJs did get a bit excited, and the noise was, and the music was maybe a little bit higher than it should have been.
Well, I can see Councillor Bell is waiting, putting his hand up, but if we were minded to allow you to say keep the garden open later, I mean, how long are we looking to let this run for? If the government changes run through to the end of September 21, is that the sort of thing you'd be looking for? We are hoping, and we don't need those extended hours once everything is back to normal. The pub was trading at a very likable level before the pandemic. If we could keep this until the pandemic has been declared over by the government, that would be amazing. And please bear in mind that in the meantime, we will make sure that a member of staff, whether it's the general manager, the head barman, or the security, will be in the garden at all times, monitoring
people's chat. There will be no music played. This will be literally socializing in the garden for an extra hour. The problem we've got is that at 11 o'clock, when we ask people to move in, everyone leaves.
Okay, I'm sure Rabia will note that offer, because if we were minded to approve this, then that would be in as a condition. Sorry, I'm going to take legal advice. I can see both Councillor Bell and Councillor Plouvier waiting to come in, but
Okay.
Amanda.
No, I'm happy to wait. I'll wait.
Okay, so let's get on with the discussion then. So, Councillor Bell, I think your hand was up first.
It was simply to pursue the issue just raised. There's clearly conditions on the licence. Number 14, no regulated entertainment take place in any external areas. So how does a DJ set up and get out in the areas without breaching the current licence?
The music the DJ was playing was background music. Wasn't meant to be a disco per se. It was literally just meant to be background music so the customers can enjoy a drink. Like I said, unfortunately, one of them did get a bit more excited than he should have done.
The police representation is quite clear. There was a DJ outside playing music. In the police representation, there was a DJ outside playing music.
So before the pandemic, this event was always inside in the live room. But unfortunately, we can't use the live room at the moment because of the situation. And this is the reason why we put that in the garden in the afternoon.
Knowing that it breached your licence?
We are allowed to play background music in the garden. I understand we're not allowed DJing in the garden, but we are allowed to play background music in the garden.
This was clearly not background music.
I mean,
a DJ is not the same thing as background music.
Sir, I myself have been a few times having events in the garden with customers and playing background music. If this wasn't, if the music in this event wasn't played at the background level, and it wasn't cleared because the police were there, and like I've admitted already that the DJ did get a bit excited, I can only apologize for that and make sure it never happens again. But we do not have live music in the garden per se.
So the license is clear. It says no regular entertainment take place in any external areas.
Can I suggest? I mean, I think we're at a bit of a stalemate here. Should we just take a view from Amanda on exactly what what counts as a regulated entertainment? Should we just get that clarified? Can you have a DJ doing background music if it genuinely was as quiet as it was supposed to be? Would that count as regulated entertainment or not? Would it be?
No, in my view, it wouldn't be regulated entertainment. What I'm saying is the DJ would be in breach of the license. So I mean, background music isn't usually played by a DJ, as far as I'm aware. So I wouldn't be expecting that.
Okay, sometimes you come to this committee and you get a free legal opinion, and that's what you've just had. So thank you very much, Amanda. Should we move on?
Yeah.
Okay, Councillor Plouvier, did you have? Well, actually, no. Should we let Amanda come in now? She's bursting to come.
All I just wanted to quickly say is, you mentioned about wanting to limit the period of the license, but I think it's been made clear throughout the committee that we can't define when the pandemic will come to an end. So I don't know whether or not the police or David can confirm whether or not they would be agreeable. For example, if you did want to, if you were minded, or the committee were minded to grant a 1-year time limited period, whether or not they would agree to that. Otherwise, I think that we don't want to mislead anyone, that we can do a time limited grant of this license.
A very good point. I'm coming back to them later, and we'll hear from them then. Shall we take you first, Councillor Plouvier?
Yes. Yeah. I mean, it's unfortunate to come to a hearing and display that you have breached various conditions and caused a problem. I want to go back to the police's concerns. I'm not reassured by an older clientele. That actually is a more at-risk clientele. So it doesn't make me feel happier that your clientele at this event is 40 to 60 rather than 20 to 30. You may think they're quieter, but they're actually more at risk. And you haven't answered the police question about social distancing and procedures regarding COVID. And so I have to say I need some reassurance from that.
Okay.
Back to the applicant, yes.
We did reply to the police. We sent an email explaining exactly what happened.
Sorry. The police evidence here is what we have. We don't have. I'm not criticising you in that sense. I'm just saying that we need that information because it hasn't come out in the hearing, and those questions still stand.
Okay.
Okay. Yeah. So, sorry, applicant, can you tell us what you told the police?
Yeah. So the social distancing was in place on the day. We had 25 people in the garden. The capacity of our garden allows us to have around 50. So the garden was at half capacity on the day. And all the COVID measurements were in place.
So just to go into the detail, all the tables wherever it's possible, they are set to a 2 meter plus from each other, like be creating the bubbles, and it's never less than 1 meter plus. We also have sanitizer stations outside, inside, and on certain key points. We have signs put up everywhere, inside, outside, in the bathrooms, of reminding people of social distancing, proper hand washing procedures. All the staff is wearing visors, we wear aprons, and we are keeping a distance. We take all the customers' details as well, whoever walks through the door. Every single person, the name and the phone number is kept on file for 21 days as requested by the NHS.
Oh, that's fantastic. Thank you. So assuming that Kerry's happy with that side of things and we're only dealing with the noise issue.
Okay, can I just say, I mean, I hope you've been to the very useful briefing sessions that licensing has been running with the various pub watch networks. And I have been finding in some of the hospitality venues that I have visited, there is a wee bit of misunderstanding. So just to clarify and make sure you understand it, it is 2 meters separation unless there is something physically between you, i.e. a screen or a mask or something like that. And people seem to think at least 1 meter means 1 meter. It doesn't. It means 1 meter plus something else. So I hope that's what you're following. Okay, where are we on this? That's the applicant. We've had the discussion. Do my fellow committee members feel that they need to hear more before coming to a decision? No, from Councillor Pluvier. Councillor Bell? Any more questions? Can you hear? No. Okay, thank you. And Amanda, can you just say if there's anything that you think we should have addressed that we haven't done yet? I'm going to ask David and Kerry to talk about if we were minded to give it for a limited time, what their view will be. So I'm still going to come to that one in the summing up, but anything apart from that?
No, that's fine. Everything else is fine. Thank you.
Okay, so
what about condition? There was a condition 25 that they wanted removed. Have you dealt with that?
Oh, you picked up on that one. Sorry, we've so focused on the hours on the back garden. Yeah, well, 25 is the one that says the beer garden at the rear of the premises should close at 2300. So essentially, that is exactly what we're discussing at the moment. Yeah. Okay, so let us go in reverse order. What did I do last time? I can't remember, can I? I think that started this time with David. So this time I'm going to finish with David. So PC Ryan, do you want to say if anything you've heard today has changed your views, and perhaps comment on that idea of a temporary change to the limit on the outside garden?
Thank you, Chair. Nothing has changed for us. We wouldn't like to see the outside space used for an extra hour, and so I can't really comment on what date would be appropriate to put a time limit on, unfortunately.
Okay, thank you for your submission. David Tuitt, thank you. What would your take be on extending, which I've said is a bit of a generous ask already, given that the hours are quite late already, but what's your take on it?
I think, as you say, Chair, it is a generous ask. I mean, you know, we are, of course, very sympathetic with the applicant's situation, and all licensed premises operators happening across the country, various types of license that are operated. We sympathise with their situation. It's just that we do have the licensing objectives to promote, and that is the fundamental basis for our decision. Just in relation to if you are minded to grant, and it is time limited, in the coronavirus regulations, and I think the Act, there's a clear reference to an emergency period for which the Secretary of State has certain powers to bring in regulations and make directives, that sort of thing. So if you were minded to grant and approve this for the duration of the emergency period, which is clearly defined in legislation, that would be an option for you as well.
Okay, thank you very much. Where have we got to? Closing remarks from responsible authorities. So just got the applicants to hear from. Are there any points that you feel you need to add in making your case?
I just would like to add quickly that I believe we're a very important part of the local community, and the pub has been here for over 150 years. We are a listed building. We've been voted the most beautiful. We won a lot of awards. So we are asking for this because we need it for our survival, unfortunately. With the new restrictions and the regulations, we are very much struggling to keep the pub open and alive and our employees employed. So we really hope that that we can get this granted, because it would be really important for us.
And I just had one quick question for Amanda, if I may. Amanda, would you be able to send me an email to clarify the difference between a background DJ and a normal DJ, so we don't make any mistakes going forward?
There is no such thing as a background DJ. There's background music or DJ. They're two separate things.
Okay, I'm sure we can look into that and clarify. I don't know if there is case law on it, but if anyone's going to know, it will be Amanda, and we'll pass that probably back through David Tuitt, because he should be your line of contact with the council.
Chair,
I have a question or a contribution from Councillor Bell. Councillor Bell.
I'm just trying to think through how we would achieve this if we were minded to do what the applicant wants. And looking at the conditions and the hours, it would seem we cannot remove condition 25. We need to amend 25 to allow for the later opening hours of the garden if we were minded to do that. I just wanted to raise that before we left the applicant.
Thank you, Councillor Bell. I too had that thought, but let's get it out in the open and let's make sure we all understand that. Okay, so any final clarification? I mean, whatever our decision today, and it will be announced to you in the next day or two, please, we aren't here as a business support. We try and do everything we can to be sympathetic to business, but do make sure you're availing yourself. You're on the council business support networks, and you're ensuring you get all the support that you can from that, because we do like our hospitality business. It's a hugely important local business, and we don't want to see anyone be driven out of business. But we are where we are, and ultimately we have to make our decisions guided by the licensing policy, and that's what we will do. Have I covered everything? Councillor Plouvier.
Raised this before, but I don't know if this pub premises has an off license. I don't know if they've availed themselves of those facilities. I noticed they make food, they make pizzas. I just wondered if that was part of their operation currently and if that had expanded at all.
No, unfortunately not for us. It didn't work out. We tried takeaway, Deliveroo, and all other portals, but for us it just didn't work out. In fact, the kitchen has been reduced to only 3 days a week at the moment.
That's very sad. A lot of places are now operating to reduced hours. I'm very sorry to hear that. I think we have covered everything, unless Amanda tells me different. So in that case, thank you for putting your case. Thank you to the regulatory authorities for contributing today. Time for you to leave now so that we, with our legal advisor, can consider these two applications and make our decision. And you will be hearing from the licensing service in the next few days with the outcomes. So thank you everybody for helping us make that decision today. Thank you and goodbye.
Thank you.
Thank you very much.
Thank you.
Thank you.